Hello and welcome to Matter of Fact. I'm Peter Van Onselen. Thanks for your company. Well, the Banking Royal Commission resumed hearings in Melbourne this week with evidence of financial practices that the Treasurer Scott Morrison described as deeply disturbing. The evidence related to admissions by AMP and the Commonwealth Bank that they charged clients fees for services that they did not receive. Reporter Daniel Ziffer has been covering the hearings and he joins me now from Melbourne. Thanks for your company. It was very much the AMP that were in the spotlight yesterday. The CBA joined that today, but both of them are still very much under the pump, aren't they?
It's been a punishing few days in the Royal Commission in this second round of public hearings. What we've started with is what's called fee for no service, and that really is like what it sounds. They have charged customers fees for not providing something that in many cases they knew they would never be able to provide. The detailed allegations against Commonwealth Bank and AMP go a long way, and a long way up the tree. Yesterday, probably the most shocking revelations with regards to AMP is that the board, specifically the chair, Catherine Brenner, interfered or potentially interfered with an independent report about this issue which they were sending to the regulator. So there were 25 recommended changes made to this supposedly independent report which was then sent to the regulator. One of them was to remove the name of the then CEO Craig Mellor and say that he was unaware of the problem. So this is a report that they sent to the regulator, the Australian Securities and Investment Commission. One of 20 times they admitted they have made a false or misleading statement to the regulator. Now, the Treasurer talking today, Scott Morrison noted that sometimes making false or misleading statements to the regulator can lead to jail time. Really strong language from a Federal Treasurer about one of Australia's largest financial institutions.
One of the other interesting things that the Treasurer said today is he noted, I saw, that ASIC was already looking into some of what's been happening around fees for no service prior to the Royal Commission. That's, in my estimate, him trying to send a political message there. But do you get the impression from what's come out, you've been there the whole time through the Royal Commission, that more will be able to be uncovered with the powers of this Royal Commission?
Royal Commissions have extraordinary powers. Now, the Treasurer revealed that previously unknown ASIC investigation into AMP. They've dragged in 18 staff. They have also very large powers. Royal Commissions, as you would be aware from covering previous ones, are very unpredictable. They can ask for documents, they can compel people to answer questions, so we just don't know where this is going to go. Now, this is a very brief Royal Commission. Everything that Commissioner Kenneth Haynes says seems to suggest he wants to hit that deadline of a draft report by September, a final report by February. They're going through this stuff very quickly. In the first lot of public hearings, we covered pretty much everything to do with consumer lending. Most of the ways that if you're watching at home, you'll use the bank. Home loans, car loans, credit cards. Now we're into a broader realm, financial planning and wealth management. So again, this is the big four banks and AMP who together dominate this field, and they are under an exhausting spotlight. We're looking at improper conduct, fees that should never, ever have been charged for people, and terrible advice. And every day in this commission, more executives are dragged into a very harsh spotlight and forced to answer some extremely uncomfortable questions.
Well, later on in the program, we will have our panel and we will get into some of these fascinating issues around the politics of this and indeed whether there is enough time for this Royal Commission to uncover everything that the public might expect. But on one of those issues you just touched on, fee for no service. Extraordinary admission, wasn't it, from CBA today under questioning from counsel assisting that they would win the gold medal were they being handed out when it comes to this sort of action.
Well, they would win the gold medal in a canter. They'd do it without breaking a sweat. The big four banks and AMP have returned more than $200 million to customers in compensation for fees for no service that they've uncovered and they've sent back to customers. Of that $200 million, 118 is from the Commonwealth Bank. They are the gold medalist by a stretch for this behaviour. Now, this is by no means to exonerate the other institutions. They are all going to get their whack in this next fortnight, that is for sure. But for AMP, some really, really tough issues to digest. misleading the regulator, knowingly saying that they had remediated customers, they had solved the issue, and yet, as was revealed yesterday, even in the scripts that they gave to call centre staff for when customers would ring up and say, hey, why has this money appeared in my account, they were still lying and saying that it was an administrative error. It wasn't an error, and the evidence shown in the Royal Commission showed that a lot of people knew about this. It went to an extremely high level, and they did a lot to keep it going as a deliberate business choice. This was not a mistake.
Dan, as I mentioned, you're covering this extensively. You've been there the whole time. A lot of people wouldn't necessarily know the distinctions between the big four banks and which sections of the bank is dominant in which particular areas of banking. Am I right in understanding that the CommBank is very much in this financial services space the dominant player?
Well, the four banks and AMP comprise 48% of this market. Now, they've grown massively. Evidence heard today was that the Commonwealth Bank in the last 10 years had doubled the amount of clients or the size of accounts that it was servicing, and yet the number of advisors had only gone up by 25%. A lot of them are spinning off or getting out of this realm. It's quite complicated. This kind of vertically integrated model where you create products and then you have advisors that sell them creates either conflicts of interest or perceptions of conflicts of interest. So Commonwealth Bank, they're selling off Colonial First State. Others have spun off similar divisions. There have been huge problems in financial planning. This is not the first inquiry that's looked at that. But you are seeing here some real issues from those structural problems. Commonwealth Bank certainly dominates. AMP is huge in this space. And with an ageing population and the trillions of dollars that are in superannuation, a lot of people are seeking advice about the end of their work life, about moving into retirement. And that's where a lot of these problems have occurred.
Dan Ziffer, we appreciate your insights. Thanks very much for your company.
Anytime.
Well, the public admissions by the financial services industry this week begs the obvious question: how have they been getting away with it for so long? If the Treasurer finds the practices deeply disturbing, what does the government need to do to ensure that they don't continue?
So by my count, this was the 14th false or misleading statement by AMP to ASIC. You're losing count. And again, by my count then, that brings us up to the 15th false or misleading statement. And I think that takes us to 17.
Were you counting that as one or two?
I only counted that as one. Do you think I should count it as two?
I think in fairness, Mr Hodge, you should.
Okay. The 18th false or misleading statement by AMP to ASIC. By my count, this is the 20th false or misleading statement made by AMP to ASIC.
Selling what you can't deliver, selling what you won't deliver, selling what you don't deliver.
Customer signatures were forged or falsified. Customers impersonated, where there had been fraudulent uses of powers of attorney.
Obvious, isn't it, that you can't charge somebody for 90 days for providing services that you're not going to provide. You agree with that?
That's correct.
And you know that Commonwealth Bank group entities have charged more fees for no service than any other financial services entity in the country. Do you know that?
I do know that.
It would be the gold medalist if ASIC was handing out medals for fees for no service, wouldn't it?
Yes.
It's clear that we preference the interests of shareholders in that exchange at the expense of clients. And so that is a concern.
My question is it a matter of concern for you how it is that that smaller number of advisors can meet all of their commitments to that greater number of clients?
And what has occurred here and what has been admitted to in the Royal Commission by AMP is deeply disturbing.
What the Royal Commission, without certainty, will establish is that change is needed. It is needed desperately and it is needed urgently.
This type of behaviour can attract penalties which include jail time.
Well, to discuss this issue further, we really do have the perfect panel this evening. Professor Alan Fells was the chairman of the Australian Competition and Consumer Commission from its inception in 1995 until 2003. Rod Bristow has worked in the financial services industry for the last 15 years. He's the former Chief Operating Officer of CommSec and is currently the CEO of MacroView, a Sydney-based investment firm. And Bernie Ripoll is a former Labor MP who chaired the parliamentary inquiry into the financial planning industry, which led to the Future of Financial Advice reforms in 2012. He's now the Managing Director of financial advisory firm Fresh Advisory. Welcome one and all. Thanks for your company.
Okay.
Thank you.
Thank you.
Bernie Ripoll, I might start with you. It's been a long time coming to get to this stage of having the Royal Commission, but the timeline for it is quite quick. The Commissioner himself seems keen to stick to it, but a lot of people, including Coalition MPs, are saying that it's not long enough. The draft report later this year, and then, of course, the final report due in February next year. What's your estimate on this? Do they need longer?
Well, let's see what Kenneth Hayne finds in this commission. There's obviously some very, very tough questioning. The commission already is uncovering a lot of information, and I think let's give this commission an opportunity to get through at least to the interim report in September, see what comes out of it. This is a really important process for everyone to really participate in, and I think what we're seeing out of the commission right now shouldn't be a judgment about whether it's long enough or not. It's really about the quality of work that comes out of it. And I think so far, people watching would be horrified by what's coming out, but impressed by the work that's being done by Hayne and the Commission.
Alan Fells, can the quality of the work happen in the quick turnaround time?
It's hard to say, but I'm a bit sceptical. And it's not only that you need to dig fairly deep into the facts across this complex industry with many products, it's also that deep thought needs to be given to solutions, to tackling systemic behaviour that is harmful to consumers and the public, and also perhaps going to some structural issues. It seems to me that the issues are so serious that thought will have to be given to whether some structural changes will be imposed on the industry, like banning those who make financial products from offering advisory services relating to those products and products of competitors. That will take some time and thought.
Rod Bristow, I mean, from your perspective, looking at this industry, things like vertical and horizontal integration, do there need to be changes in that space?
It's a good question, and I think, I agree with Alan that the issues that are coming out of the Royal Commission need to be considered very carefully, particularly in relation to what might change. I think the key message that's coming out so far is around that structural change. Has the industry historically been structured in a way that is taking into account a more balanced perspective on all of the stakeholders that the industry is serving?
Okay, let's talk about something around ASIC. Now, I might come back to you, Professor Fells, on this one. The government for a long time was saying we don't need a Royal Commission because ASIC has the powers to investigate. They ended up calling the Royal Commission, some people would say because of the political need to do so rather than some sort of desire to do so. Yet today, as recently as today, we've still seen Scott Morrison referring to the fact that ASIC was already investigating some of the things that have been uncovered in the Royal Commission. Do ASIC, in your view, have the powers to be able to do what they've been doing and do it effectively? And does this Royal Commission add anything?
I think even before we talk powers of ASIC, we have to look at their own culture. They have had a rather weak culture of enforcing the law, and there's been a whole lot of aspects of that. Now, in addition, they probably need some stronger powers and more resources and more ease of proving matters in court by structuring the law so it's slightly easier to prove cases.
Do you agree with that, Bernie Ripoll?
Well, Peter, look, I think there's a lot of truth in that. I think what needs to be considered here as well is that we did a lot of heavy lifting a number of years ago following through from the Storm financial collapse and making sure that the laws were changed. The laws are in place. They need to be enforced. They need to be enforced rigorously. And if that's not taking place, then that ought to happen. The other point to note is that not only have we got good laws in place, but what we're finding through this misconduct commission is really that people are deliberately ignoring the law, that institutions, the big banks, AMP, have admitted that they're just ignoring the law. I do think we'll probably need to strengthen a number of areas, but ASIC has always got the opportunity and has used it on many occasions to actually tell Parliament when it feels laws are inadequate or its own powers are inadequate and it needs more. If this is the case today, then ASIC ought to step forward and say what it needs to make sure these things don't happen, don't continue to happen, because they've obviously been happening while the laws have been in place.
See, Prof Bristow, one of the challenges here is that if people are breaking the law, then changing the law or tightening the law doesn't necessarily achieve anything. It becomes cultural, doesn't it?
Yeah, it's a good question, and I think part of that is definitely an issue. I think that, you know, really the concept that I've been thinking about and talking about and writing about for some time here is around the concept of social licence, and you know that implies taking a broader perspective on the role that a business plays in the community, and that's well beyond just legal or compliance. It's actually about taking a considered view about understanding all of the stakeholders that an industry or an organisation might be working with, and making sure that that organisation is planning and delivering on those stakeholder expectations. So it's very much beyond just legal compliance, absolutely.
And Professor Fells, do we need changes in a broad sense to Corps Act provisions around shareholder interests? Because a lot of business people that you talk to, not necessarily just in the realm that we're discussing here tonight, they talk about this idea that, well, the shareholders' interest has to come first, not the customers. That's what we're required to do by law. Now, it's obviously a lot more complicated than that. You've examined businesses well beyond the banking sector. What do you think about that?
I don't think shareholder interest should dominate these things. There are social requirements and economic requirements of businesses that must be satisfied first, and in particular the interests of customers should be put first. And unfortunately the forces of markets and competition aren't enough to fully protect customers, so you need quite strong laws, particularly in financial services, to override the immediate interests of shareholders. By the way, there's another set of questions about whether shareholders have enough influence on how firms operate, for example, regarding executive remuneration.
What's your view on that?
Well, a few years back, the Productivity Commission successfully recommended a two-strikes rule, where if at two general meetings voters opposed the remuneration report, there should be a spill of the board. That is having some effect, but I am concerned that in that inquiry, which I was actually involved in, the financial sector, particularly the banks, kind of got off because it was said they were being looked after by APRA. But APRA only dealt with a tiny aspect of the problem.
Bernie Ripoll, I remember doing an interview some years ago now with a former colleague of yours, Senator Sam Dastyari, and he was intimating at the time that the banks were too big, and perhaps one of the outcomes that was required from a Royal Commission was for them to be downsized and carved up. What's your thoughts on that?
Well, I think that's happening right now. I think, Peter, what's obvious is that the business model that the banks have been using for some time in terms of vertical integration is a failed model. It doesn't work for them. They're not capable of managing that properly, certainly not to manage that, adhere to any laws that are in place, particularly to protect consumers. And I think we're seeing an unravelling of that business model now. Can also just say on FOFA reform, these were major reforms at the time, and in fact, if you recall, Peter, there was an avalanche of opposition around these laws, that they were going too far, that this would destroy the sector. There were all sorts of calls for this was the end of the financial services world, and yet what we see happening now is that, you know, the banks and AMP have now admitted they actually ignored the law, they actually breached the law. I think there's a lot to answer for here, but just picking up on a point that Rod made around social licence, I think what we're seeing here is a really large failure of leadership all the way across the top of the major institutions and the banks. We're seeing a failure of culture within the banks and an absolute failure of integrity. I think people watching the Royal Commission must be absolutely, disgusted with the behaviour of the banks. It's a great disappointment to everybody. There was an opportunity through the FOFA reforms. There was a soft start to give the banks plenty of time to implement the reforms, and an opportunity for some self-regulation based around the laws, and an opportunity for them to do the right thing. They've proved they can't be trusted, and I think that's really what's coming out of this Royal Commission now.
Rod Bristow, I mean, you've worked in ComSec, in the belly of the beast, if I could put it that way. I mean, do you think that we're past the point where self-regulation can in any way, shape or form happen because of the public's attitude, and for that matter, the policymakers' attitude off the back of what we're hearing?
You know, is it too late? That's an interesting question. I think, you know, the issue that Bernie's referring to there around the FOFA reforms, I think to some extent proved that the wealth management sector did struggle with the concept of self-regulation and needed, I guess, a bit of a kick along to make sure that the regulatory framework was appropriate to the model that they were operating. I don't think it's just, you know, we're talking a lot about the Royal Commission, which is right, and, you know, it's important to, if we look a little beyond the headlines and what's coming out and think about what's being achieved here, is we're shining a light on some really important issues. And for me, one of the important issues that we're shining a light on is taking a more three-dimensional view of the operating environment that a lot of these businesses are operating in. And, you know, inevitably, if you ask a business, you know, what are we here to do? The response will come back in some way, shape or form as, you know, shareholder return. But I think this is starting to show an opportunity that, you know, return for shareholders is important, absolutely, because businesses need to grow because of all the flow and benefits, and they need the support of shareholders. But there are a whole range of other issues that need to be taken into account in terms of what environment is that business operating in, who are the stakeholders in that environment, how can we make sure that as we're generating those shareholder returns, we're achieving these broader outcomes that clearly the community is expecting. I mean, Bernie would know this better than anyone, but since 2009 we've had more than 50 inquiries into the financial services industry, and that's a clear indicator that I guess our social licence issue there is not where it needs to be.
Well, that was my next question, as an open question to all three of you. We might work our way through you one by one as quickly as you can on this. So many inquiries in such a short space of time, plenty of recommendations implemented, not all. Are we at a point where this is the end of the chain, Professor Fells?
I think the time has come to look at bigger structural solutions. The inquiries, as you say, have not really had the desired effects. Now, we've already heard about the case for vertical separation, which I think really needs to be seriously looked at by the Royal Commission, but also horizontal separation. That is, the banks traditionally have been deposit takers from us, the public, and business and lenders, but they've also got into big investment businesses, risk-taking activities. Now, the trouble is that the banks have prudential backup, lender of last resort support from the central bank. They've become too big to fail, as it's said. But when things go wrong in this investment area, that threatens the viability of banks, and then the burden on the prudential regulation is too big. And we should separate the areas which require prudential regulation from normal business activities. We should consider breaking them up, as the Vickers inquiry recommended in the UK.
Bernie Ripoll, your reaction to that as a former public policymaker?
Well, I think there's some really good points there. Look, one of the key things that comes out of this for me is that we need more competition in this space. It's clear to me that the big four is just not enough. There's not enough competition, and I think it's one of the things that I think the Commission should look closely at when it makes its recommendations to make sure it enhances.
What ways, if I can jump in, what ways can it do that though?
Well, I think to pay particular attention to the smaller and mid-tier banks and their ability to compete. It's not a level playing field. I think there needs to be a closer look by the Parliament and regulators around how to better have competitive mechanisms operating, and Alan would know probably better than anyone, but I think that's part of the solution. There needs to be more competition in the market. I think the other one is that there'll continue to be more inquiries and perhaps even another Royal Commission if they just don't learn their lesson, and that is if there continues to be misconduct. The community expects a lot more, the Parliament expects a lot more. These aren't partisan issues, they certainly shouldn't be partisan issues. I think that great failure that I talked about earlier and that Rod talked about in terms of a social licence, I think there's been a real breakdown of trust. And what's clear as well coming out of the Royal Commission is just how far away, how far distance these executives are from their own business and their own business model. They don't really understand what's happening in their own businesses. They either can't manage them because they're too large. They really don't get what's happening, what's going on at that real core, and they're certainly not looking after their clients, their consumers.
Rod Bristow, on that issue of the structure of these big organisations, the sort of matrix-style structure, is it one that doesn't have clear enough lines of accountability?
I think it's hard to generalise. I think that, similar to what we've been talking about with all of the inquiries, and to some extent some of these things take time to resolve. It's, when you're talking about big structural and big cultural changes, whether those changes are legislative, whether they are related to business structure, they will take time before we see the impact. As to what are we looking at in terms of what might come out of the Royal Commission with structural recommendations, we have to wait and see. I think, we do have, very high quality senior executives working in these organisations who do understand the complexity that's involved. I think some of these issues that have been talked about in the Commission do go back some time as well. And so, with all of the inquiries, with all of the recommendations that have come out, I think sometimes we need to let a little bit of time pass before the impact of that change will truly be felt.
Professor Fells, when you headed up the ACCC, you approved at the time a number of these sort of takeovers and structural adjustments with the banks. Now, I know that you've noted that you didn't have the power not to because of the nature of the rules and regulations and legislation at the time. Was that a failing of the political class?
Well, all around the world, competition laws are about competition. Now, when the banks took over financial planning, when they took over wealth management, there was no competition between them and the banks. So not an issue under competition law, and probably competition law should remain like that. But I do think, as I've said earlier, something needs to be seriously considered in the way of legislation that tackles these problems we're talking about tonight, the issues of horizontal and vertical breakup.
Gentlemen, we are out of time. Just a very quick one, if you can get it quickly for us, Bernie Ripoll. Your prediction, does a shortened Labor opposition accept this outcome of the Royal Commission, or is there politics to be played before the election?
I think that'll depend on the quality of the interim report in September, and I think then the final report in February. But certainly, look, from what's taken place just in the last few days, if not few weeks, I think we can expect to see a lot more. And the expectation then, the pressure will be on the Parliament to actually respond to the recommendations made by the Commission. Bernie Ripoll, Rod Bristow and Alan Fells, thanks one and all for your company. Appreciate it. Thank you.
Thank you.